So that brings us to the last of the 4 statutory areas, and this is trade secret. So trade secrets are information that is secret and valuable because it gives you a competitive advantage. When I talk to my clients about this, this is just generally stuff you don't want your competitors to know. It could be anything. It could be customer list, could be your bid you're submitting on a government project. Obviously, you don't want your competitor to know that, or they'll submit one for $10 less. Could be the formula for Coca-Cola. And in the US, we also require you to undertake reasonable efforts to maintain the secrecy of that information. Maybe this means guards, limits on access, only those who need to know it get access to the Coca-Cola formula, non-disclosure agreements, NDAs, or confidentiality agreements with your employees and anyone else who's given access to the secret. So if you want us to protect it legally, you got to take some steps to protect it as well, so you're not always running into court. And if it becomes public information and everybody can find it out on their own, then it's no longer a trade secret. Now again, it doesn't require true secrecy, only reasonably secret. And so I always joke with my students about this. You know, how many people can know information and still be secret? And the answer, of course, is 2 if one of them is dead. So we don't require true secrecy, because if it was truly a secret, only you knew it, you would never have to sue anyone else over it. But this is information you're going to use in your business. You may have to disclose it to some employees so you can exploit it efficiently or produce the product you're trying to sell. So other people are going to know your secret. And so it has to be reasonably secret, not true secret. Now, it only protects, if you have a trade secret, against misappropriation. If someone wants to go out and buy your product and figure out what makes it work, how it's put together, that sort of reverse engineering is not sort of within the scope of the trade secret misappropriation. That is legal and legitimate. But if you go and hire a former employee, or you get them to breach the duty of confidence that they signed on to, or you use wiretapping or corporate espionage, sort of improper means to obtain the secret information, then that constitutes misappropriation. And so, of course, reverse engineering very common. When Chrysler first came out with the minivan in the 90s, Ford and a number of other automobile companies went to Chrysler dealers, bought a bunch of the vans, and then took them apart to see how such a popular product was made, and then they tried to copy it as best they could. And that's legal under trade secret law. Once you put that product on the market, others are free to copy it. Okay, so you have these 4 different areas, but of course you're not relegated to just one, right? It's not, you only get one and no other. You can pick as many as you want, and sometimes to protect effectively your product, you may have to combine a number of these different areas, though sometimes there's one or more that makes the most sense. So if you've come up with this jack-o'-lantern trash bag idea, what sort of IP are you going to use? Now, obviously, trade secret's not going to work, because as soon as you put this on the market, everybody can see exactly what it is you're offering, and they can just reverse engineer by buying your product on the open market. Copyright, you might think it's an artistic design. You probably could get a copyright on that. But keep in mind, copyright provides narrow protection. That is, it only protects against copying. So if someone does their own jack-o'-lantern trash bag with a slightly different facial appearance, then you're not going to be able to sue them for copyright infringement. And it only protects your expression, not your idea, not the idea of a jack-o'-lantern trash bag. So if they want to do their own version of it, that is not going to be copyright infringement. You might be able to claim it as a trademark, though here it's a little troubling. First problem is that to become distinctive, you have to sell enough of these trash bags so people start to identify it with you uniquely. So it may take some time to develop that distinctiveness, and that may give your competitors a window to jump in. And then the second problem is that this is also the function, right? The whole point of the trash bag is to look like a jack-o'-lantern. So court may be unwilling to give you a trademark or trade dress in what's really the principal feature of the product. That leaves you with patent. Now, utility patent probably out. This doesn't hold leaves any better than the existing patents. Doesn't even, existing trash bags, doesn't even do the job any differently. But there's also in the US a design patent, and industrial designs are protected in different ways around the world. In the US, we do them through a design patent. This is for the non-useful ornamental features of chairs and tables and any sort of industrial product. And so the inventor here actually got a design patent on the jack-o'-lantern trash bag, and so was able to maintain exclusivity in the market. Didn't hold up over the long term, but they got at least the first 2 or 3 seasons under their belt, and that gave them a real window in which to recoup their investments. What about the perfect opener? Well, you can see you got the trademark there at the top, the words perfect opener. They've got the little TM up there next to perfect. In the US, we either put TM or R in a circle. If you've obtained a federal registration, which is not a prerequisite for trademark protection, but really helps you out in terms of some of the procedural aspects of it, you can use the R in the circle. If you don't have a federal registration, you probably don't have a trademark, so you put the TM. And saying, I wish I had a trademark. But you might be able to get, again, copyright, not going to be much help. Trade secret, not going to be much help. You got a trademark on that, but people could change it pretty readily. So you're going to have to use a combination of design and utility patents here to protect your product from imitation. And they're not going to do the job perfectly. Often the best sort of IP protection is not a legal protection. It's just doing the best job, getting your product out there first and best, and at a good, fair price, and then consumers become loyal to you. And so probably here, design and utility patents, utility on the combination of features into one particular product, and a design patent on the shape of the opener, the pill caddy. There are also in the US a few miscellaneous doctrine. I'm not going to go through them. The last one I should mention expressly here, the non-disclosure agreements and covenants not to compete. These are essentially just contracts. They're not really IP because you don't enter into them with the world. You can only enter into contracts with specific people, but you can get your employees to promise not to compete with you or not to disclose your confidential or proprietary information. So contracts are a very flexible device in which you can use on a one-on-one or one-on-a-few basis, but a negotiated basis to get people to agree not to take, or if they do take, compensate you for use of your idea.